The Supreme Court intervenes in the ghost gun case, plus an interview with gun rights lawyer Alan Beck on his recent wins against Hawaii's strict gun laws. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter right now if you want to check out the latest in what's happening with guns in America. This week, we're going to be discussing several rulings against Hawaii's strict gun laws with the lawyer, the gun rights lawyer, who's responsible for having them blocked or tossed. That is Alan Beck. Welcome back to the show, Alan. We've had you on a while back to talk about some of your successes with stun gun laws across the country. And now there's sort of another theme or pattern that we see in some of your litigation here. And this one is specifically focusing on Hawaii's laws.
Yes. Thanks for having me, Steve. Recently today, a judge, a couple days ago, I prevailed at the Ninth Circuit on a butterfly knife case, and the Ninth Circuit found that knives as a general matter are constitutionally protected, and specifically Hawaii's ban on butterfly knives is unconstitutional. And
then one day later, you had another ruling?
Yes, sir.
In a separate case?
And then the next day, literally the next day, we were granted a temporary restraining order against several aspects of Hawaii law regarding the census of places ban on carry. And that's essentially what Hawaii had done is after the Bruen decision, where they were required to issue permits. And after Bruen, I had a case, Young v. Hawaii, and that sort of put the...
This is another Hawaii case that you were involved with about open carry, right?
Yes. It was actually just about some form of carry. They completely banned carry over there.
Right.
And that sparked them to need to pass what they call SB 1230. That banned carry in virtually the entire state. They really mimicked the bans that have been passed in New York, New Jersey, and Maryland, and are being proposed in California and Massachusetts. And in that sense, they were banned. They put in something called a default rule, where a business has to affirmatively put up a sign or otherwise give consent to allow a person to carry. And then they simply banned carry, didn't even give businesses the option in many other types of businesses. And on top of that, they banned carry in parks and beaches, along with government parking lots, all sorts of places. And we sued...
We have banks and restaurants as well. Right.
Yes, and we sued in the county of Maui, and that comprises it's technically 5 islands, but there's only 3 populated islands. The other 2 are just very small. And of the 3 populated islands, that's Maui and Molokai, and the other one starts with a K. I can't pronounce it. Lanai. I'm sorry, Lanai. Those are the 3. 96.4% of the county of Maui they ban carrying under SB 1230 under Hawaii law. Now,
under these sensitive, they basically said that 96% of the county of Maui is a sensitive place of one sort or another. That's what you're saying?
Sir. And we went through the various publicly available county maps. This all just and just extrapolate from that off we figured out how many businesses there were, all the different parks and beaches, etc. It worked out to be 96.4%. There's a little bit of a standard deviation there because we didn't know exactly the size of a road, for example. So we use the average for roads. So I think maybe say roughly 96%. That can't be. You cannot say, the Supreme Court cannot say they have a right to carry a firearm, and then for a state to ban carry in roughly 96% of the publicly accessible state outside the home. That just breaks. That doesn't pass spell test. So
I think there's a lot of people who would who may agree with you on that, but at the same time, there was a recent ruling actually out of Montgomery County, Maryland, up near where I live. I'm in Virginia, Northern Virginia, and the judge in that case, found that their sensitive places restrictions were okay, even though that county was almost entirely blocked off from legal carry, even if you have a permit, just like Maui. But your judge, in your case, who, by the way, was this is an Obama appointee, correct?
Yes, Judge Leslie Kobayashi.
Mm-hmm. And she found the opposite, right? She came to the opposite conclusion of the judge in the Montgomery County case, even though they're both appointed by Obama, is my understanding, if I'm remembering this correctly. And you've managed to convince your judge that, this 96% or these sweeping gun-free zones don't comport with the Second Amendment, essentially. What was it essentially in that reason? Because she does talk about this recent ruling in Montgomery County, but disagrees with it, comes to a different conclusion. What was her logic laid out there?
Well, just as an aside, I'm saying 96% as for just to illustrate the point of how harsh it is. I don't want any of the viewers to think that that's somehow a magic number. this could be 50%, sure. Right? But that just
but it's in line with what a lot of these other jurisdictions that have passed this rule you're talking about, the default rule or the vampire rule, some people call it, where they've switched the understanding that most basically everywhere has always had about gun carry, which is that it's all right inside of publicly accessible private property, so a storefront or a restaurant or something like that, unless the owner posts a sign saying that it's you're not allowed to carry a gun. They flipped that assumption around so that now all publicly accessible private property is off limits to gun carry unless the owner posts a sign saying you can carry, which obviously has this huge effect that you're describing with these percentages, right? That most places become off limits. I think in New York, the governor described it as when she was asked where you'd be legal to carry, she said some roads. And it sounds like that's basically the same situation that you ran into.
Effectively, roads and sidewalks are where you can carry in the state of Hawaii. And, what our judge did is simply apply precedent. And that's something that the Maryland court did not do. Under Bruen, the burden is on the government. Once you have said you want to engage in protected conduct, in this case, carry a gun, the Supreme Court was very clear. The burden is on the government to affirmatively prove that that there's a historical tradition of banning a carry in these locations. And that bottom line is just simply wasn't done by the state of Hawaii. And the reason they couldn't do it was because there simply isn't any historical tradition of banning carry, say, at a beach or a park. And we showed, the judge acknowledged that I produced evidence that banks have been around since the time of the founding. There have been banks for thousands of years. At the founding era, there were banks in at least New York and Massachusetts, several other states, had banks, and there were no restrictions by the government. Now, there may have been restrictions by the bank itself. That's a whole different kettle of worms. And the state of Hawaii attempted to simply rely on laws that restricted carry in markets and fairs. But here's the interesting thing.
Right. They said that was somehow similar to banks.
Yes. But these laws, I looked at these laws, and it turned out that they didn't actually ban carry in markets and fairs even. There are only two supports for banks were bans on carry in a threatening manner. And I don't think that they won any favor there by relying upon laws. And honestly, I think misrepresenting the laws initially until I pointed out and looked it up myself. But that's all that happened, though, is our judge faithfully applied precedent. And that's in line with what's been done by the court in Antioch. I'm sorry, go ahead.
No, yeah. One of the more interesting provisions, though, in this ruling to me, because I think it extends well beyond Hawaii itself, right? Some of these things extend to the other states that have tried to pass these post-Bruen response bills that have these sort of novel provisions like you're describing there, the default swap provision where or banning guns in banks or at all sorts of different venues. But there was one provision in this bill that I think is fairly popular in a lot of states, which is restaurants that serve alcohol. States handle this differently, but it's not uncommon for them to just ban you from carrying in at all in an establishment that sells alcohol. Some of them do, like, if it's more than 50% of their business comes from selling alcohol, they try to make essentially bars and taverns off limits, while other restaurants that serve alcohol are allowed for carry. But this is something that's not as much of an outlier as some of these other provisions, and yet the judge found that there wasn't historical support for that. Can you walk us through that section of the ruling?
Yeah, something that's important here is it's not just restaurants and bars that serve alcohol; it's their parking lots. And a big problem with this law is, my clients like to go to Maui Mall. Maui Mall has, dozens of different businesses. One of them is, O'Reilly Auto Parts place. One of my clients frequent. He is not allowed to carry when he goes to O'Reilly's because there's two restaurants in Maui Mall that share a parking lot without O'Reilly that do not allow, and because of that, he can't carry in any of these businesses. That doesn't make sense. But ultimately, though, to get to the underlining point that you're asking about is whether or not there may be historical tradition of making people who are actually drunk, that have been drinking, not allowing them to carry. But at the colonial era, there was absolutely no laws that said you can't go to a restaurant where that happens to have alcohol and carry a firearm as long as you're not drinking. And or at least, and the reality here is the state wasn't able to produce any evidence, that either at the founding or at the Reconstruction time, a person couldn't get himself a steak at the local pub, eat it while carrying. And that's what they were required to do. So while it may be that there are more laws impacted because in the 20th and 21st century, it's become a little more of a tradition to more states have allowed these types of bans, doesn't impact the analysis. So what we look at is the founding era.
But it has implications for those other states potentially.
Oh, sure. Absolutely it does.
Yeah. Because, they did bring up a couple of laws, right, in this section. They pointed to some militia laws from the founding era that talked about not allowing people who were on duty carrying their firearms for the militia to drink while they were on duty, right? That was essentially the context of these laws.
And that is a tactic that was directly rejected by a different judge in Hawaii in one of my other cases. I had a case where the only historical analogs they were able to produce, and this was a pre-Bruen case, they tried to rely on militia laws for inspection of militia arms to justify forcing the Hawaiian people to bring their firearms to this police station to have them inspected prior to registering them. And, even prior to Bruen, Judge Seabright, who, one of the other judges in Hawaii, said, look, that's just simply not relevantly similar. I mean, these are laws to maintain military discipline. That has nothing to do with a person in civilian life being engaged in, what he can do with his private firearms. And so the court, relying upon that rationale and just simply their own logic, said, what a person does while they're in the military have anything to do with what they're doing in their private life.
But also, even if you take these militia laws about not drinking while carrying a firearm to be a historical tradition of banning that practice, that's obviously still not the same as just going to a restaurant that happens to serve alcohol while you're carrying, right?
Absolutely. This is a very large number as a practical matter. I mean, you'd be hard pressed to just simply randomly go get lunch at a place in, that doesn't serve alcohol. I mean, there's a lot of places that serve beer and wine. It's not a big part. This is not, the state, and I'm sure a lot of the anti-gun groups want to paint this as bans on carrying, some type of nightclub, where the whole purpose, where just alcohol is just the purpose of going there. There's plenty of just simply normal diners that you'd be surprised. I mean, they have beer in the back if you want to order from it. So,
most restaurants serve alcohol.
And this impacts my clients' just day-to-day life. That's something I made very important with this judge. It's not about a special occasion where you're going to some fancy restaurant and getting expensive, and where expensive wine is being served. This is them on their lunch break. This is just everything. Yeah.
And look, I think that it sure seems like this ruling could have some influence over these post-Bruen laws, in particular in New York and New Jersey, Maryland. We're soon to get one in California, probably Massachusetts as well. And so it'll probably have some influence in those cases that are stemming from those new laws. But I think this provision probably has some implications, even further afoot than that, right? Because there are far more states that try to regulate carrying in restaurants that serve alcohol than there are states that are passing these sort of Bruen response bills. But, the other interesting thing to me about that case is that, you're taking these cases in an area that's traditionally been very unfriendly towards Second Amendment challenges of gun laws. The Ninth Circuit, Hawaii in particular, these are not places that are that you've seen a lot of wins over the last 20, 30 years until very recently. And so, now you're sort of racking up some of these wins, and including at the appellate level now. This other case that you mentioned briefly at the beginning there, it was a Ninth Circuit panel. They found that butterfly knives, right, the sort of, hard to describe them. They're kind of like nunchuck of knives, I guess. People, if you've ever seen like a 50s gangster movie, you've seen somebody like, I don't know if they're in West Side Story or not, but that's the kind of movie you would see a butterfly knife in. But essentially they've got the two handles and the knife is in the middle. But it's something that was banned in Hawaii outright. You couldn't possess these even. And this panel found in favor of your clients, coming to the decision essentially that the Second Amendment does protect these knives. Can you just explain maybe some of the logic there, how they came to that conclusion?
Well, I think what's important is that we remember that the Second Amendment protects a right to keep and bear arms, not firearms. And that's a misnomer that's made by a lot of people. And so we have to look at what is an arm. And since we're talking about constitutional law here, we have to look at what the definition of an arm was at the time the constitutional amendment was passed. Here, because we're talking about one of the Bill of Rights, one of the ones that was drafted in 1791, we look at 1791. And as the Heller Court says, by citing to several dictionaries that from the founding era, one of them being Timothy Cunningham's dictionary, an arm is anything that you take in your hands to strike at another or put on your body to defend yourself. The last part I was paraphrasing, but and so what that means is that an arm is any type of weapon that you yourself can carry upon your person and use to attack another person or defend, or body armor that you can wear upon yourself. So not some type of wall that you construct, but something that you individually can wear. And well, butterfly knives fall safely within that definition of what an arm is, because like knives, like any knife, you can pick one up and use it to defend yourself or to attack a person with. In Heller and the Bruen decision, in dicta, mind you, knives are used as an example of an arm. And as a more practical matter, knives at the founding were part of the required arms used that you had to show up with muster with. Not butterfly knives, typically bayonets, but the point remains that knives are part of the traditional complement. So this is not really a stretch to say that a knife with two handles rather than one is protected by the Second Amendment. And that essentially was.
It's very similar. It's very similar to sort of the argument that you had made in a lot of those stun gun cases.
Yes,
right?
Absolutely.
Because stun guns aren't firearms, obviously.
Yes. But they're portable, man-portable weapons that we use to defend themselves. And that's the first step. Mm-hmm. Now, is it an arm?
Yeah. So you got to the point where you're showing that this is covered by the second. This is covered by the text, right? These are arms.
Yes.
And so you still had the historical analysis step.
Yes. Right?
Is there any tradition of regulating these? And so what was the outcome of that?
And during the colonial era, there was absolutely no tradition of regulating any knife. During the Reconstruction period, from about the 1830s towards Reconstruction, there were some restrictions on the carry of something called a Bowie knife.
Bowie knives.
Typically, these were just concealed carry bans, and just one or two places actually banned their carry. And the state of Hawaii attempted to analogize to the Bowie knife. Well, first, there weren't enough restrictions, according to the court. Two, there were no bans on possession. And three, the butterfly knife is much more like a pocket knife, and there's never been any restrictions whatsoever on pocket knives than a Bowie knife. And so the court found the state did not do an adequate job to justify its ban with a historical analysis.
Right. I think go ahead.
Well, I mean, there are a couple points, just sort of practical points here, and that doesn't necessarily go into the post-Bruen legal analysis, but I filed this case in 2019 before Bruen. So I have a wealth of public policy information as part of the trial court record and as part of the pre-Bruen briefing on appeal. And one, I had an expert who is a Filipino knife fighting expert named Bertrand Richardson, who lives on Oahu. He did a demonstration with a variety of different knives. Butterfly knives open the slowest of all the folding knives, simply because there's more moving parts. The reason they have all these parts, they have split handles, they want a safer knife. So if you fall out of a tree, while you use this utility knife, the knife doesn't somehow like spring open and stab you on accident. But as a result of that mechanism, you cannot. It takes a while. It takes not a lot of time, but a couple seconds to open, rather than half a second. It's there's.
But it's fun to open them. That's sort of where Hollywood these made them famous, because they're flashy. You open them by flicking them around like a nunchuck or something.
Yeah, it's just a really ridiculous ban. But I mean, just simply as a matter of public policy, the state of Hawaii was not able to really justify its ban. The only thing you could say was that there were criminals caught with these bans. I took a look at what they meant by this. And I decided to do a deep dive into the arrests with butterfly knives. And for the most part, not all, but for the most part, the number one thing that I could find was delinquent high school students. They're truant, the police catch them. Maybe they're smoking a joint, something like that. And they happen to have a butterfly knife on them. And they're charged with that as well. And so the state of Hawaii is trying to say these are
not charged with an actual violent crime.
Correct. These are the state of Hawaii's position was these are weapons. They're not typically used for lawful purposes, because here's evidence of criminals being caught with them. Therefore, this is a weapon that's used for criminal purposes. Well, one, even if there's 100 arrests, if the normal use is for non-criminal purpose, and these weapons are used all across the world, both for self-defense, martial arts training, a handful of arrests does not cancel out. Two, as I pointed out, it's not, it's ridiculous to say a couple high school students taking sixth period off have to get a ticket for being truant, and then it turns out they've got a butterfly knife on them. That doesn't correlate with the butterfly knife being particularly dangerous. It just happens to be that this is a traditional Polynesian Filipino weapon. There happens to be a very large Filipino population in Hawaii. So the Ninth Circuit addressed this and just said, well, all weapons are associated with crime. Somehow, handguns, certainly. I mean, criminals simply use weapons to commit crime. That doesn't nullify a weapon's constitutional protection.
That's interesting. I mean, it kind of sounds like perhaps this butterfly knife ban was maybe just like a low-hanging fruit of these types of hardware bans that you could challenge, because there's really not a very credible argument even on the practical side of why this should be banned. But I'm sure some people are wondering, all right, doesn't knife news, that's interesting. It's just Second Amendment related, but does this tie back to something people are even more interested in, things like assault weapons ban? It seems like this precedent set by this panel does imply a lot for other types of hardware bans, because the same basic analysis is going to be done presumably in an assault weapons ban case or something of that nature, right?
Yes, I mean, it is true that a lot of the underlying logic is going to be applicable to any type of hardware analysis in a lawsuit. And right now, Judge Roger Benitez has a case called Miller v. Bonta, and he also has Duncan v. Bonta. Miller deals with California's assault weapons ban, and Duncan deals with California's ban on magazines. I have a magazine case in Hawaii that's behind the Duncan case called Abbott v. Lopez. And this lawsuit is going to directly implicate the logic here. But I would stress, though, that there's a lot of space between a butterfly knife and a AR-15. I mean, I'm sure the state of California is going to get extremely creative. So I don't want to say it's dispositive, but certainly this ruling assists in, it sets a foundation of what the courts have to do. And that's something that wasn't there. It was just something lacking.
Wasn't there before.
Yes.
Yeah. And that makes a lot of sense. I mean, but yeah, you're right that obviously butterfly knives and AR-15s are pretty far apart in practice in real world and both popularity and use. But at the same time, the Bruen analysis is supposed to be the same for both of these things.
No, you're right.
I think they're probably going to have to rely on a lot of the same laws that they brought up in your case.
They will. I mean, a lot of this
to defend themselves.
Yeah, a lot of this is going to be very similar. I mean, you're absolutely right. I mean, it's going to be the same history, and they're going to have to deal with the same precedent. I mean, it's certainly a big push forward for the Second Amendment. And in fact, the attorney who's doing the Illinois assault weapons case, who also is one of the attorneys that worked on the Bruen case, is named Erin Murphy, and she has already filed a notice, a letter, a correspondence with the court to update the court about new cases. And she relies specifically on the Teeter case, this butterfly knife case, and demonstrates that the legal reasoning is the exact same. And if this court applies the Ninth Circuit's legal reasoning, the Seventh Circuit applies the Ninth Circuit's legal reasoning, then it should come to the same result in her challenge to the assault weapons ban in Illinois.
Yeah, so we'll have to watch for exactly how this ruling plays out in other courts, because I think it's going to have a significant impact. But you actually have another case that you just filed in Hawaii. So tell us about that. This one deals with some very specific and novel requirements when applying for a concealed carry permit. Is that right?
Yeah, so one of my clients in the butterfly knife case, James Well, lives on the Big Island. And after the county of Hawaii began issuing permits, he wanted to get one. So he goes to the Big Island, the county of Hawaii Police Department, and starts the application process. He is asked to sign a waiver, where he waives his attorney-client privilege, his medical doctor privilege, his priest privilege, his spousal privilege, all of his confidentiality. And then there's just simply a catch-all at the end, about half a dozen of these, and any other privileges that he may have. So that means, and this is all.
Yeah.
So I want to be clear, Stephen.
I'm very confused. Like they're saying that he has to waive like even the privilege of talking to his lawyer. Like he'd have to share everything that he's ever told his lawyer or his spouse or his priest in order to get this permit. No.
His attorney would need to. Not just him, his attorney. They could take in his, and let me be clear, this waiver form, look, I mean, this may not be the intent, but this waiver form is very clear. It's a complete waiver of attorney-client privilege, right? A complete waiver of priest petitioner privilege. So let's just say you have a business attorney, completely unrelated to your eligibility to own a firearm. This gives the county of Hawaii the right to go into your business attorney's office, and let's just say you have some trade secrets at the reload. You go grab all the trade secrets that your attorney has for safekeeping, take it, and here's the best part, Stephen. Then later on in this waiver, it says, I kid you not, and you waive your right to sue the county of Hawaii or any of its subdivisions, like the police department, if it releases your information So now I'm dead
Which
serious.
is a real risk, as we saw
Yeah.
in California.
Yeah. So let's just say, there's no, and by the way, I mean, it actually doesn't say negligently. I mean, you can just simply have someone that doesn't like you over there release your information. But let's just say now, you are now a Hawaii resident, Stephen. You want to, you still own the reload. You want to go get yourself a CCW. They go to your attorney's office, grab all your business files for whatever reason. They want to do a real deep dive. The law enforcement officer takes the box to while he's having lunch. He leaves it there. Someone from whatever your rival organization is picks up the box, publishes all your information online, uses it to destroy your business. You have no cause of action against the County of Hawaii. You've waived any right against the County of Hawaii. Your doctor, you can have something incredibly traumatic that happened to you in your life, and they accidentally release that on something incredibly embarrassing. Maybe you're dying of cancer. You don't want the world to know, and if they release that, you cannot sue the county. So not only is this a huge violation of your privacy, just simply to allow a law.
But even without the releasing stuff, yeah, I mean, even if you ignore the possibility that it could be released, I mean, this is all it's like stuff they don't. Why do the police need this information? Why? How do they figure they have a right to it? I guess
you're absolutely right, Steve.
I suppose that's what the lawsuit's about, right?
Well, yeah, no, you're absolutely right. I mean, the release of liability is just icing on the cake. I want to be real clear. I mean, there is absolutely no right for the police to go looking through, your therapy records, your what you tell your priest, what you tell your wife. When you waive your spousal privilege, just means they can compel your wife to come testify against you if they want. I mean, this is just a massive invasion of privacy. It's
so what grounds are you suing on, by the way? Is this Second Amendment grounds, or what are you
we're suing on three separate grounds. One, we are suing under the Second Amendment, and just like this impediment to your right to carry. And two, we're suing under the 14th Amendment right to privacy. And the courts have made it very clear. You have a fundamental right to privacy in your medical records and other intimate things, including the constitutional right to attorney-client privilege. And then we're suing under the Hawaii Constitution. And the Hawaii Constitution actually says the government has an affirmative duty to maintain privacy, which, Hawaii government's subdivisions, like the counties, are not supposed to, they're supposed to minimize anything that hurts your privacy rights. And so we've got these three different provisions we're suing over. I'm very confident we're going to win on this because this is just egregious. I mean, it's something that honestly just bothers me that they think that, you have a right in this country, not just for a whole host of reasons, to have an attorney, be able to say what you want to your attorney in private. Criminal defendants, imagine our system of justice if you couldn't tell your criminal defense lawyer what you wanted to say. I mean, that would just simply that puts our whole system of justice on its head. And this is something that needs to be stopped at the beginning. So I filed a preliminary injunction, and the county has an opportunity to respond to that in a few weeks. So I'm very interested to see what the county says in response to this lawsuit.
All right, so we will absolutely keep on top of that one and see where it heads from here. I'm very interested in seeing what the outcome ends up being. But one last thing before we go over to our news segment. Obviously, there was a terrible disaster in Hawaii with these wildfires, especially on Maui, which is actually where a number of your clients in the sensitive places suit live. So are you able to tell us if they're okay, or have they gotten through the fires as far as you know?
They're all okay. But there's cell phone service is extremely spotty. The power's out. No one in Maui is having a good time of it right now. They have been able to briefly call me or otherwise contact me. So I do know they're okay. That's good.
That's really good to hear. And if people want to, help support the folks who have been affected by that wildfire, I think they should, you can check out the Red Cross and other registered charities that are working to get relief out there, because it's one of the worst natural disasters in Hawaii in a long time, as far as I understand. So, we're praying for people out there, and hopefully your clients will come out of it all right as well. But I just wanted to ask, because it's obviously a huge news story right now in a terrible situation. But I'm glad to hear that they're doing well.
Oh, thank you for asking, and I'll relay that to them.
Absolutely. And, if people want to follow your work and follow the suits that you're filing, because you're not with like any major gun rights group, you're kind of doing this independently. Where can they find more from you?
Well, I have a business Facebook page. You can just look Attorney Alan Beck, and that should pop right up on the Facebook. I keep updates on.
All right, wonderful.
Yeah. So I'm
you keep people up to date on all the cases that you're in with them.
Yes, sir. And also you can go on the Hawaii Firearms Coalition website. That's a very small state group that I help with, and they also do a lot of updates with what's going on specifically in Hawaii. My page, I have litigation elsewhere, so I also do that. But and if you're a Hawaiian resident, I very strongly suggest you start following the Hawaii Firearms Coalition page, and 2, consider becoming a member, because we put up all sorts of information, especially during the legislative session. And, we have, this is how the bills get killed beforehand is, average citizens show up. And that means I don't have to get involved if enough people show up to legislate. So especially if you live in Hawaii Firearms Coalition.
All right. Thank you, Alan. We're going to head over to the news update now.
All right. Thank you very much, Stephen. Thank you for having me.
All right, ladies and gentlemen, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined, of course, by Reload founder Stephen Gutowski. How are we doing this week, Steve?
I'm doing great, actually. Doing really good because, and let me tell you why. The Phillies are on a hot streak.
Oh,
but not just that. We just picked up a pitcher at the deadline, right? Lorenzen. And his second game with the Phillies, his first game at Citizens Bank Park, he threw a no-hitter.
Yeah.
And I watched that whole game, and it's one of the most amazing experiences in watching sports that I've ever had. So it was, I wish I had been in the stadium, but it was basically just as good watching it from home. It's just so much fun. Philly sports can really do a number on you, on your soul long term, but it also goes the opposite way when they actually win. So this is a Stoutland University shirt I'm wearing for those on YouTube. That's the coach of the offensive line for the Eagles. So pretty happy. And the Eagles have their first preseason game this week too. So excited about that as well.
Yeah, I'm not even a big baseball fan, but when I saw that someone threw a no-no, it's pretty cool.
You know what else too? That game was crazy. First of all, it shouldn't have been a really good game for the Phillies. I mean, they were playing the Nats, who are bad, right? Just plain bad. But this was a game where they were resting a bunch of guys. They brought up guy from like this, I think he's like 27 or 28-year-old minor league player, his first game. And, you know, they were playing a lot of their backups. And so you think, well, maybe they could pull it out because the Nats aren't very good, but you're not expecting some amazing thing. You know, Lorenzen had a great first game too. He only gave up 2 runs in 8 innings. So he was already paying off pretty well. But, you know, then you get, first off, the very first at bat for that minor leaguer who came up. He hits a home run in his very first at bat in the major leagues. So that's amazing. And then Castellanos hits 2 home runs. He gets the 200 home run mark. And that was all before you started to notice that, oh yeah, no one has gotten a hit yet. And we're in like the 5th, 6th innings. But he had thrown a ton of pitches too. You know, I don't want to turn this into a baseball podcast or anything, but in modern baseball, they don't let you just pitch 9 innings anymore.
Right.
You know, people aren't going out there and throwing 130 pitches a game or whatever like they used to way back. And so he had a couple walks and he had a couple long at bats early in that game. And he even said after the game, he was worried he was not going to make it very long in the game. But then, you know, turned around, he got a couple quick, you know, innings in. He got a lot of good defensive help. Nothing like, there weren't super crazy defensive plays that anybody had to make, but, you know, it was a lot of fly balls to center field. Actually, I think our center fielder has only played 20 games in the league, had 9 outs in that game. So, you know, there was definitely a team effort in getting this no hitter. But, yeah, I was watching it, you know, while doing work and stuff. And I got a stupid notification on my watch from the MLB. They're like, hey, there's no hitter happening, which is like terrible luck.
Jinx, yeah.
Yeah. But Lorenzen overcame that. And now his cleats are going to be in the Hall of Fame. He was wearing Vans cleats, by the way. He's like a California guy. And so his cleats are made by Vans. But yeah, it's been a good week so far. How about you?
Yeah, no, I don't have quite the same uplifting story in Colorado sports. I watched the Rockies lose like normal last night, so I don't have the same high that you're riding. But I'm happy for you that Philly has had some good luck recently. So
yeah, and I also scheduled the next Homes for Our Troops charity shoot.
Oh yeah,
so we're doing 2 this summer because the person who won 2 years ago wasn't able to, get their whole family, everybody they wanted to come together in the same time period. They got like adult children, so they want to have a couple people come out. But now we've got a date scheduled it's the end of September. I'm looking forward to that one as well.
Yeah,
so
that'll be
hopefully
awesome.
Hopefully it'll be as good as the previous ones. But what do we got in news?
Yeah, we've actually had quite the week in terms of especially court rulings. So we'll kick it off with one that I wrote about a federal judge out here in Colorado. On the day that the law was set to take effect, issued a preliminary injunction on their recently passed ban on all gun sales to adults under the age of 21. So he said that was likely unconstitutional under the Second Amendment.
Yeah, and that's continues a trend that we saw even before Bruen. You were seeing a lot of rulings just based off of Heller alone that were coming down in favor of 18 to 20-year-olds because that's also an area that, basically the law is kind of conflicted with public opinion in a lot of ways because people are moving increasingly towards wanting to ban 18 to 20-year-olds from owning any kind of gun. But, the Constitution has been getting in the way of that, I guess, or at least the federal judge's interpretation of the Constitution has. And so, yeah, we see that again here. I mean, this one of the more extreme versions where you just can't own any guns, basically, even if 18-year-olds or adults often live on their own. But, it's sort of a demographic thing, I think, in a lot of cases, because a lot of 18 to 20-year-olds, not a lot, but not in raw numbers, certainly the percentage of people who are that age bracket that commit crimes is still minuscule, but it's a higher proportion than other age groups. But obviously you get into a lot of problems when you look at people that way on the demographic scale and try to pass off, the bad acts of someone else onto another person because of their demographics.
Right.
So.
And that's that's kind of what went into this ruling here, because Colorado attempted to kind of draw an analogy from historical dangerousness laws. For example, folks that wouldn't sign like loyalty pledges to the country, and because 18 to 20-year-olds are dangerous, that's an analogy. And the judge, kind of to your point, said, that's way too broad. You can't say that just this entire class of people falls into some dangerousness category. So yeah, it just continues a trend that we've seen of almost exclusively striking down these age bans. So I think we've seen one in the 11th Circuit, and that's being reheard en banc. So we'll even see if that holds up.
The Florida ban, right? Yeah, and obviously I think the other sort of glaring point is that if you're looking at historical tradition of arms in the United States, 18 to 20-year-olds were included in the militia in basically every single militia act that was passed at the founding. And they were not only allowed to own guns, they were required to own guns so that they could show up and muster with them. Yeah. The historical aspect is super weak as well in these trying to support these bans. So, and
just a quick note on that. Just a fun fact: it didn't get raised in the lawsuit, I don't believe, but Colorado's Constitution specifically says men 18 to 45 are in the state militia. So it's just funny that it even has their age right there. And our state this was a federal case relying on the federal Constitution, but it's just funny to note that historically, yes, they were considered part of the militia and required to be armed in some cases.
I mean, it's not even like historically, right? Because it's not like,
true.
18-year-olds still serve in the military today. It's not something we only did in the 18th century. This has gone through our entire history. So, it gets pretty hard to see how these laws are going to withstand the kind of historical scrutiny required in Bruen, and they're not. Right? I mean, I guess that's the point. Outside of that one case that you mentioned, they really haven't withstood even before Bruen, like I said. Yeah. So, of course, we'll keep on top of it because that just because something is protected by the Constitution doesn't necessarily mean that people at large think it's or like it, right? I mean, you see this really with all constitutional rights. A lot of people want to, they don't like the Fourth Amendment's various protections all the time, and they don't like the First Amendment's various protections all the time. And you're going to see the same thing with the Second Amendment as well. Yeah,
I think that's right. But speaking of court rulings and sort of another trend that we've started to see, this is a little more recent, but the Fifth Circuit has a new ruling out where they, in an as-applied challenge, struck down the federal prohibition on unlawful users of controlled substances. In this case, it hinged on marijuana, a person that was admitted to smoking marijuana on occasion and also was in possession of firearms, and he was sentenced to 4 years in prison. The Fifth Circuit came down and said, we're going to toss that conviction, we're going to toss that indictment, and that this is unconstitutional as applied in this case. So pretty big deal.
Yeah, and they were pretty specific about their ruling being limited to just marijuana users, but obviously the implication there could go much further. And certainly I think this is an area where you have probably a lot more support than normal for undoing a gun law like this, because so many people now legally use marijuana, and that if they even touch a gun, basically, you don't even have to own the gun, just possess it. That makes you a felon under federal law. And as this case demonstrates, right, they went through the historical record, and there really isn't anything similar to our modern day lifetime ban on gun ownership for drug users, right?
Right. Yeah, there's a pretty good tradition at the founding and then later during like the Civil War era of restrictions on using guns while actively intoxicated. Usually alcohol was sort of the laws, but there's nothing that says like, if you use alcohol once, suddenly you can't own a gun, a month later, a year later, 5 years later, or whatever. And that's sort of what this came down to in this case. Is like, look, you can't just blanket ban someone for life because at some point they used a substance. And that's sort of how the U.S. government lost this case, was on that.
Right. And it's very similar to what we had just talked about with Alan Beck on the main interview with the carrying in restaurants prohibition in Hawaii, because the logic in that case was very similar to the logic in this case. The historical record was basically identical, and they came to essentially the same conclusion, that historically, there were prohibitions on people, at least militia members, drinking while being armed. That wasn't allowed. But so some sort of intoxication, really any kind of intoxication while carrying a gun or possessing a gun would be probably in line with the historical tradition. But going well beyond that to just anyone who's ever used marijuana or uses it occasionally, it would be just like saying anybody who gets drunk can't own a gun. And so that's where the courts seem to be coming down on a lot of these things now. Intoxication is the key more than just that somebody used at some point. We'll see how that holds up when you get to harder drugs, I guess.
Right.
Maybe the courts will see a difference there. Maybe we'll get that Hunter Biden case since his plea deal got all messed up. We still don't have a resolution on that yet. You could absolutely see a US v. Biden Second Amendment case that's along these same lines. I mean, we talked about in that scenario how these charges are not brought very often as standalone charges, but clearly they do happen sometimes. That's what this case was, right?
Yep.
This guy was not convicted of anything else. And as far as I'm aware, he wasn't accused of anything else other than just having weed and guns. At the same time, he wasn't accused of being high while possessing the guns, just that he admitted to using drugs. Usually that gets you out of charge. Usually don't charge that stuff, but it does happen. And so that's where, when people talk about the Hunter Biden situation, I think that's one of the things that sticks in their mind. Like, this is not a common thing. It's not a common charge, but if it happens for this guy, why not for the president's son? Right. It's what you'll often hear. But, at the same time, this precedent really could help Hunter Biden if he does end up facing charges for this.
Yeah, wouldn't that be quite the precedent?
I mean, that would be quite the news story at the very least.
Sure. But yeah, so we'll keep an eye on that. And that kind of brings us to our last story, because we have a court ruling, limited as it may be, from the highest court in the land. The Supreme Court finally made its decision in the ongoing saga over President Biden's ghost gun rule, where the Supreme Court gave deference to the DOJ and is going to allow that rule to be enforced while the litigation keeps going. Yeah,
they issued a stay and they gave us a whole paragraph to work with on trying to interpret what they're doing with this. Basically the order just says we're issuing the stay, and that the stay is going to remain in place not until the Fifth Circuit gets done with this case, which is interesting, but until the Supreme Court decides what they want to do with this case. If the stay says if they decide not to take the case, then the stay goes away, but immediately. But there's a number of ways you can look at this one. I wrote a whole members piece on this, right? And you could look at it from a pro-gun rights advocate point of view or a pro-gun control advocate point of view, and you could come out with evidence for either side, I think, because here's the thing, right? We've talked about the Supreme Court and emergency interventions twice before in gun cases, right? And what did the court do then?
Right. Yeah, they decided to give deference to the lower courts and not intervene.
Yes. And what did they do this time?
Right. Now, all of a sudden, when DOJ comes calling, it's suddenly a little bit of a change in attitude from the high court.
Mm-hmm. And they decide that actually we're going to get involved in what the lower court is doing and issue a stay.
Right.
Of course, there's another point on this end, which is that if you look at the stay, they also mention who didn't want to issue the stay, right?
Yeah.
And it was all conservative justices, right?
Right.
Four of them said no. It was Gorsuch, Kavanaugh, Thomas, and Alito. They all wanted to say no to the stay. So Roberts and Barrett are the ones who joined with the three liberals on the court to issue the stay. So that's a bad sign if you're a gun rights advocate, because this split the conservatives on the court and didn't split the liberals on the court.
Yeah.
So maybe that says something. It also has the court going against the Fifth Circuit's determination that the stay wasn't necessary because blocking the rule actually reverted things back to the status quo, because the rule was what changed the status quo in the first place. So that's something. Those are things to go off of. Of course, the other hand, you have a number of things to consider. First of all, it's not a Second Amendment case, right? This is obviously it deals with gun policy, but the claims aren't Second Amendment claims, at least not the ones that the courts have actually ruled on.
Right.
This is administrative powers, right? This is the Administrative Procedure Act is the key bit in this case. And so, it's not actually a Second Amendment case. That's one thing to note. Of course, the court has been equally skeptical, maybe even more so, of administrative power, executive branch power in recent years. So I don't think that's any more fertile ground for people trying to defend the ghost gun ban, but it is a key difference. And then, of course, like you mentioned, one of the big differences, in my view, is that the government was the one requesting the emergency action in this case, and they're requesting a stay instead of an injunction, right? And so those are two different things. The previous gun cases, those were both plaintiffs requesting injunctions or requesting for a stay to be lifted in the New York case, and the court didn't want to get involved in blocking a law in that way, I guess. And they're much more likely to default to procedurally to what the government wants to do. This is one of the reasons that you saw very few Second Amendment cases between, Heller, McDonald, and Bruen, because the government wasn't appealing any of those cases. They were winning all the ones at the lower courts.
Right.
And so, the court could have taken, of course, they do take cases from non-government, plaintiffs or defendants, but they're very deferential to taking cases from the government, especially the federal government. And so that's why you saw Rahimi happen almost immediately after Bruen.
Yep.
Because it deals with a federal law that's been blocked or struck down, and it was a request from the federal government. And so that's why you might see a greater pace of cases coming forward out of all this. But,
yeah,
what does this all mean for the merits? I don't know. It's certainly not what gun rights advocates wanted to see happen, right? Clearly. But it's not something that it's like, oh, well, they're obviously going to side with the government in this case, or even that they're obviously going to take this case up if it does, once the Fifth Circuit does issue their ruling.
Right. Yeah. No, like you said, it is an unusual thing that they stayed it even despite whatever the Fifth Circuit will eventually rule. But as you said, that's no guarantee that they're going to then come in and take the case. They could just say, we like what the Fifth Circuit did, we'll deny cert, and then that's sort of that. So it's sort of just kind of up in the air right now. We'll just kind of have to wait and see.
And even if they did take it, I wouldn't think that necessarily means the government's going to win.
Yeah, agreed.
On the merits. I would still think they're more likely than not to rule against the ATF in this case. But we'll have to obviously wait and see. They could, if those 6 justices that issued this stay wanted to say something about the merits or even hint at what they think on the merits, they could have done that. You kind of saw this in how they handled the New York emergency application, right? The plaintiffs in that case wanted the Second Circuit stay removed while the case was being heard, and the Supreme Court said no, but Alito and Thomas wrote a concurrence in that case that mentioned we're just doing this to, let the procedure play out in this lower court. But we kind of like the ruling, right? I mean, they compliment the ruling, go out of the way to say something about how they like the ruling against New York's law. And, obviously that's just 2 justices, but it's, it gives you perhaps some insight into at least the conservative wing of the court in that case. Whereas in this one, nobody said anything. And the conservatives who dissented didn't say anything either. So, it's hard to read the court. You can't. These are all tea leaves, right? I don't want to get too far out over the skis here, but you know that their silence could say something that basically if everyone was already decided on the merits of this case, which presumably they wouldn't do before they actually heard anything on it, but you might have seen a little bit more coming from the justices than you did. This may just be limited to a disagreement over whether the stay should have been in place, because the Fifth Circuit not giving them one is a bit unusual, I think.
Sure.
You often see the government get stays in these sorts of cases while the litigation is ongoing. So, you know, and the court might just be sort of reestablishing the status quo as they view it. But we'll have to watch and see exactly what happens. And people can go ahead and read more in my members piece about this over at the Reload. And if you don't have a membership, well, you can go and buy one and get access to that, as well as access to this show a day early and the opportunity to be on the show if you would like in a member segment. We'll have to do another one of those soon. It was one of my favorite segments that we do on this show. And of course, if you're not ready to make that jump and buy a membership, you can support us in all kinds of other ways. We are independent publication here. We're not backed by any major corporation or billionaire donor or whatever. All of our funding comes directly from our members buying memberships. So that's very important for us. But you can also support us by just signing up for the newsletter that we send out for free on Friday mornings. Every Friday morning, we do not overload your your inbox with just tons of news. We send you one email a week, and then if you're a member, you get a second special email, exclusive email on Sunday, giving you a more thorough rundown of the week's events, more analysis of it. But you can, of course, also help us by liking and sharing this podcast, giving us a 5-star rating on whatever platform you're listening to this on. Those are all super helpful things. But until next time, I'm going to let you guys go. Thank you.